Welcome to TLD Talks, where we share insights about key legal and business matters that are impacting SMEs today. Bringing together experts from a range of backgrounds, we tackle the issues that matter to you. I'm Ed Simpson, the founder of The Legal Director, and on this podcast episode, we're doing something slightly different. A couple of weeks ago, client legal director and employment law expert Kate Palka presented a webinar on recent and upcoming changes in the employment law landscape. We thought it was so useful and relevant to all SMEs that we've decided to incorporate it into one of our podcast episodes. I hope you enjoy it.
Hi everyone, and thanks very much for joining. 2024 is a big year for employment law, and obviously if, as expected, there's a change of government later, then 2025 is going to be even bigger. So what I thought I'd do is I thought I'd cover it month by month because the changes are coming thick and fast. And the kind of things we're going to be looking at cover flexible working rights, new sexual harassment protection, new tipping rules, what to do if you have a serial complainer. Many employers will know that scenario very well. Dismissal and re-engagement, otherwise known as fire and rehire. Holiday pay and entitlement, big changes there. Going to look at a couple of cases on religious and belief discrimination, TUPE changes, family-friendly rights and data protection changes, and that's just a flavour. To start off with then, January, we do need to probably understand the context around Brexit and what's happening with European law, because apart from the government possibly changing, we do have many of these changes coming about because of Brexit. So just as a background, the retained EU Law Revocation and Reform Act, passed in 2023, was intended to end the special status of EU law. EU law automatically applied in many areas prior to Brexit. This is going to be a long-term exercise by the government. Basically, the REUL has ceased now to exist as a special category of domestic law, and it just assumes a new legal category called assimilated law, which basically gives the government the right to change it as it sees fit. So Parliament is going to go through thousands of statutes to either decide whether or not to revoke or reform, in our case, the employment ones. And it will be publishing a dashboard and a 6-monthly report every 6 months until June 2026, setting out what changes have been made. So the latest one that they produced was produced in January 24. As it happens, at the moment, nearly 67% of EU law remains unchanged. But there is a roadmap to look at what changes are going to be made. There are many employment laws that were affected by European law, which is why I'm raising this. The government has described the changes it is going to make to REUL concerning employment rights, and bizarrely, they've also identified the wine sector as another area of massive change, but they've described the employment changes as key reforms. At the moment, though, we haven't got massive or substantive policy changes as a result of what the government has done. In employment law, to date, they've just made amendments to the working time regulations and the TUPE regulations, and they've simplified annual leave and holiday pay calculations. To give you some idea of the regulations that are going to remain as is, we're not going to see any changes to the maternity rules, paternity, to the protection for part-time workers, protection for fixed-term employees. We're not going to see changes to agency workers or the information and consultation of employees regulations, or to the working time regulations or to TUPE, with the exception of recent changes. At least some of the employment law regulations that we know and love will remain in place. To be changed at the moment, and obviously the roadmap may in future 6-monthly intervals may say different things, but at the moment they're going to remove the record keeping requirements under the working time regulations. They're going to reform the consultation requirements under TUPE, and they're going to simplify annual leave and holiday pay calculations. In terms of the record keeping requirements under the working time regulations, at the moment, this might be a surprise to many employers, but employers are supposed to keep records of daily times that people work, which was very onerous. So that's gone. So there is still the requirement to keep records, certainly of holiday and that kind of thing, but not of daily working time. In terms of annual leave and holiday pay, what we had previously was quite a bizarre situation where holiday was classed in 3 different ways. We had 4 weeks holiday, which came from Europe. We had 1.6 weeks, which came from the UK. And then you had contractual additional holiday, which you may or may not give to your employers, but you have to give them the 5.6 weeks. What the government have decided to do is they've combined the first 4 weeks and the 1.6 weeks into one leave. And I'll look at that in a bit more detail in a minute. They've also defined a new class of workers, part-year workers and irregular hours workers. That came out of an enormous amount of case law around peripatetic workers and people who only work part of the year and how their holiday pay should be calculated. So that we've got new clarification on how to define those kind of workers and how holiday will accrue for those. And also that you can pay them with rolled up holiday pay. We've got new definitions of what normal pay is, that it includes overtime, commission and other payments. Because again, there was an awful amount of confusion around how to calculate holiday pay and what to include in it. There's clarity now on when workers can carry holiday over from one year to the next. And there are changes to the record keeping rules, as I've mentioned. So there's been quite a lot of criticism, unfortunately, whilst the purpose of the new regs was to simplify the law and codify principles of EU law. In fact, what's happened is we may well have further uncertainty. So it's a question of watch this space. So as I said, combining leave, we now have one type of leave, 5.6, 28 days, and that still can include or exclude bank holidays. There was a great deal of confusion around this before. That has gone. What the government could have done as well, but which they decided not to, was actually have one type of holiday pay for those 5.6. They decided not to do that. So we still do have a bit of confusion around how you calculate the holiday for the first 4 weeks holiday pay. And do you have to treat it in the same way as the 1.6 weeks? And by that, I mean, do you include bonus, commission, overtime? Many employers just paid the higher amount, including bonus, commission and overtime for the whole 5.6 weeks, because it was an administrative nightmare to make the differentiation between them when they're calculating pay. The government could have said, no, everybody's got to be paid the same for those 5.6. They didn't, though. There is no position on bank holidays. As I said, you can still choose to include bank holidays or not in the statutory entitlement. So as I said, they've combined the leave, but they haven't combined what holiday pay actually means. If you want to pay different holiday rates for different periods of leave, so including bonus, commission and overtime in holiday pay calculations for the first 4 weeks, but not for the remaining 1.6, you must explain this clearly in your policies now. In terms of the part-year and irregular hours workers, they are still entitled to 5.6 weeks of paid holiday. It used to be the case that you could pay 12.07% on every hour as accrued rolled up holiday pay. The government outlawed that a few years ago. They've now brought it back in. So you can now use rolled up holiday pay for part-year and irregular hours workers. You must include that. For any of you who have agencies, you'll know what a key information document is. You must include an explanation of rolled up holiday pay in any agencies. If you don't want to use rolled up holiday pay for your irregular hour and part-year workers, you can continue to use what employers have had to do up till now, which is go back over the last 52-week reference period to calculate holiday pay for them. It's quite significant. It's really boring, I know that, but it affects all of us. So we do need to understand the changes in holiday. In terms of carryover, if a worker is unable to take holiday because of sickness or family leave, they now can carry over the full leave entitlement of 5.6 weeks. So that's a change in that it used to be the first 4 weeks only for sickness. They now can carry over the whole amount if they're off for the whole year. Additionally, employees can take the first 4 weeks of their holiday if they've been denied their right to take paid leave, or, and this is new, haven't been encouraged to take it, or if they haven't been informed that they would lose it at the end of the holiday year. So this is new. So what you must do now is make sure that you have a use it or lose it rule in your contractual documentation, making absolutely clear that holiday cannot be carried over if it's not taken. There hasn't been any guidance yet on what being encouraged to take it actually means. To what extent or to what ends do employers have to go to actually tell their employees about the holiday in making sure that they take it. I would say just at the moment, issuing regular reminders to employees to use their holiday. But as I said, it remains to be seen what constitutes encouraging employees to take leave. If employers fail to do this, it's possible under the new rules that employees can carry over the first 4 weeks into another year. I said we'd look at serial complainers. It is something that come across a fair amount in terms of employers asking me what they can do with an employee who just keeps bringing grievances. So this case, Hope against BMA, Mr. Hope was a senior policy advisor in the BMA. He got on well with people. His performance was good, allegedly, but a dispute arose around a report he'd written, which had to be signed off by a more senior manager. The manager didn't sign it off. He thought there were some unprofessional things in there. Mr. Hope took umbrage at that. He wanted to raise a formal concern. He then raised another issue about the line manager, who he said had excluded him from catch-ups. He only brought that one grievance at first. His appeal was partially upheld. But over the next few months, he raised other concerns about being excluded from meetings he thought he should be attending. He didn't accept it was his manager's decision to decide who should attend the meetings. He was invited to escalate his complaints via the formal processes. He didn't want to do that, but he said he wanted to be able to raise them at a later date. So he was given a deadline to decide whether or not to invoke the formal grievance procedure, which resulted then in another grievance. And so it went on. So some of you may recognise this kind of situation. This case clarified to some extent when an employer can safely decide enough is enough and ignore the latest in a long line of unsuccessful grievances. The Employment Appeal Tribunal held that the BMA had acted within the range of reasonable responses after they finally dismissed him. He'd raised 7 grievances over 13 months. Their dismissal reason, amongst a few others, but the main one, was that the trust and confidence that they had in him had broken down because of the trouble that he was causing and the time that this was taking. He'd refused to cooperate with the grievance processes. That had undermined his relationship with his manager. This was heard in January 24, and the Court of Appeal did set down some guidance to help employers decide how to deal with an employee who brings grievances in bad faith as a means of avoiding disciplinary action or as a way of causing trouble. This is difficult to judge. Every case will be different on its facts. It doesn't mean, obviously, you can just ignore previous grievances. Sometimes there really is something there in respect of which the employee has brought a grievance. It's possible, though, if an employee makes a number of petty and repetitious complaints that have been dealt with before, and if they don't cooperate with recommendations over mediation and that kind of thing, you could actually get to the point where you decide that the trust and confidence has broken down as a fair reason to dismiss him. As long as you've made it absolutely clear to the employee that this is possible, following Hope and BMA, there is light at the end of the tunnel. It may be a fair dismissal. I just wanted to look at, as well, because this was discussed, overlapping processes, because quite often what happens is that a grievance is brought during a disciplinary process. It could be a complaint around the disciplinary process itself. It could be completely unconnected. It could be about bias of the manager or discrimination of the manager who is hearing the disciplinary. You'll all recognise this kind of scenario. ACAS have produced a code of practice, and they say that you may, but not must, temporarily suspend the disciplinary process in order to deal with the grievance. And it may be appropriate, they say, to suspend where the grievance relates to a conflict of interest or bias on the part of the hearing manager, or where there's possible discrimination. My preference always is to try and either hear them separately, depending on the nature of the grievance, run them concurrently, or actually, if they are connected, roll them into one process rather than suspending disciplinary to hear the grievance. In this Gennaro and Docklands buses cases, the employee was a bus driver. She'd been reported by a member of the public and actually viewed on CCTV, clipping curbs, driving one-handed, running red lights, cutting in front of cars. So understandably, Docklands buses asked her to attend a driver assessment centre. She failed to turn up. She eventually refused to go. She was ultimately dismissed. Her appeal was put on hold while she attended the assessment centre, but she did actually fail that in the end. So that's why she was dismissed for gross misconduct. But she made quite a few allegations about some of the managers involved. But in this case, Docklands Buses decided they'd just continue the disciplinary process. And that's what ended up with her dismissal. She brought a claim. And one of her arguments was the dismissal was unfair because the employer hadn't put the disciplinary procedure on hold. Employment Appeals Tribunal was absolutely clear that there was no reason for the employer to do that. The disciplinary was actually conducted by someone who she had not brought a grievance against, and they were quite clear that it was a fair dismissal. So that was obviously for the employer in that case. I think the main thing here is to keep records, make sure you keep records showing that the grievance is being considered and dealt with appropriately and in a timely fashion, and take advice about whether or not you should suspend the disciplinary process or not. So January, we've done. Nothing in February. March, paternity leave. So this applies where babies are born after 6th of April 2024. These aren't massively significant changes, except to the dads involved. So they can now split their 2 weeks entitlement into 2 separate 1-week blocks rather than having to take them together. They can take their 2 weeks at any time within the first year rather than the first 8 weeks. They now only have to give 28 days notice for each week of leave. They used to have to give 15. They do still need to tell their employer about the fact that they're entitled, and they'll obviously have a long time to do that, 9 months. But on the whole, these aren't significant changes, but worth noting anyway. April, family and carers' rights generally, that last year and this year were big years for this. So Redundancy Pregnancy and Family Leave Act came into effect on 6th of April this year. This could be quite significant, certainly if you are thinking of restructuring or making redundancies and you've got employees who are pregnant or on maternity leave. So previously, if somebody was involved in a redundancy consultation and they were on maternity leave, there were separate and specific protections for them whereby they had to be offered suitable alternative employment if there was a job. There was no question about having to offer it to them, no interview, no selection process. If there was a suitable alternative, it was theirs. That's now been extended. So it's not just while they were on maternity leave. What used to happen is that employers would have to wait until they came back and then they would make them redundant and they'd be treated like any other employee. So the protection under which they have to be offered suitable alternative employment is now extended. Firstly, the trigger is when an employer is informed that somebody is expecting a baby. So this could be at 12 weeks or whenever the mother decides. And it goes on for 6 months after they return. So it's actually a significant extension. It also applies to those on adoption leave and shared parental leave. So what does this actually mean for employers? If you're restructuring or planning restructuring, you'll need to think through the applications because obviously you might be planning well in advance. You may not even know if somebody is going to become pregnant. The rules don't address the position for notification of pregnancy before 6th of April. And as time goes on, this becomes less of an issue. But obviously some women are caught in this. So it's only notifications after the 6th of April. This will inevitably increase priority numbers if you're looking at making redundancies and restructuring. And it does protect fathers taking parental leave as well. There's no legal authority on how to proceed when there are actually more employees with priority status than there are vacancies. And that will happen. I'm sure we'll come across that. The regulations only state that the employee's entitlement is to be offered the suitable alternative vacancy where there is one available. So it might be that you're going to have to be making selection processes, or going through procedures, if you've got too many employees with priority protection. It's not clear whether somebody needs to notify in writing, but it's likely that it'll just be a verbal notification to a manager or HR. So it's all the more important to ensure you have accurate and up-to-date records regarding pregnancy notification. Managers need to be told the minute that they are informed, they need to make sure that you know. And it does also sadly protect people who've had miscarriages, and sometimes is going to be needed to be spent in calculating the protection periods. Fairness, awareness and manager training is necessary here. And with an increase in the number of employees who could be eligible for priority status, employers are going to need to adopt systems for identifying potentially suitable vacancies across their operations. Penalties for getting it wrong are quite severe. It's an automatically unfair situation. It's potentially discrimination, which means that the caps on awards are high, potentially high. Also, at the same time, the Carers Leave Act has come into force. So currently, parents have a right to 18 weeks of unpaid parental leave for each child up to 18. They shouldn't say currently, but no right to other unpaid carer leave. The Carers Leave Act now allows people to take up 1 week of unpaid leave each year to provide or arrange care for a dependent with a long-term care need. So this is a new additional family and carers right to take up unpaid up to a week each year, with all the protections that go with taking that. Any detrimental treatment or dismissal connected to taking leave will be automatically unfair and discriminatory. There are some rules, or there's a bit of flexibility about how to implement the new right. You can divide the week into days. You can ask for notice and specify how it should be given. You can delay the leave if it would interfere significantly with the business needs. The dependents involved are not just family. It could be anyone who's ill or injured and will be remaining ill or injured for up to 3 months, anyone who's disabled or anyone who's elderly. So it's not just family, it's not a dependents leave. In terms of practical steps on carers leave, you could be looking at policies to inform employees of the new rights. You should be thinking about the logistics of requesting and taking it. You could create a self-certification form for employees to complete. You're not allowed actually to ask them for evidence of their right to take the leave. But if you have a form like this, you can put a declaration that they meet the legal definition of carer in there. You can introduce a system of record keeping to track the number of days taken. Look at support, further support, because obviously if somebody's told you they are a carer and they need emergency leave, they may have other issues that you need to talk to them about. Talk to your managers of the new right and the legal protections around it. And some employers are thinking about whether to enhance the rights. It's only a week's unpaid leave, and there is flexibility, obviously, to offer more than that. Flexible working, another new right. It's similar to the current right, but it's still a right to request and not a right to have it. This does apply to anybody, though, not just people coming back, for example, off maternity who want to change their working hours. Anyone can ask you to consider that they should be allowed to work more flexibly. They have the right to ask you this from the day they start. So there's no service eligibility requirement. You'll all know from the current system that there are reasons that you can refuse the right to work flexibly, and they remain in place. The new requirement, though, is that you have to, if you decide that you do not want somebody to be able to work flexibly, you actually have to consult with them about it. You have to tell them the reasons, hear what they have to say. There needs to be a process when the decision has been made if you're considering rejecting it. Employees at the moment can only make one request within a year. They now can make two. Employers have to, or at the moment, have to respond within 3 months. Under this new right, you have to respond within 2. So how should employers respond to this? A new employee, given a full-time role, can now make a request as soon as they arrive. And before rejecting it, you now have to consult with them. You have to open up the conversation about why their role is or isn't suitable for flexible working. So it's when you're actually looking at setting up a role and advertising for it, it might be worth thinking in advance, if it's a full-time role, why or how you're going to justify that if they come in and ask you to change it to a part-time role or home working or whatever flexibility they're looking for. Could include a 4-day work week, term time working, flexible bank holidays, whatever an employee can come up with and their imagination can make up, then they can ask you. And it's a good opportunity to identify your business's core attitude to flexible working, whether it needs to be changed. And I think even the figure I've got here now is out of date, but up to 58% now do give flexible working options. And some employers actually make it a key USP, really, to being an employer of choice. Okay, we're getting halfway through the year. We're in July. I want to look at fire and rehire. I appreciate that it's probably not something that many employers do, or certainly small to medium employers, but it's worth looking at because it's a hot topic and it will be in the news. Asda and Tesco, this has been going on for years. They proposed to remove permanent retained pay terms, which were initially brought in they were going through a restructuring and redundancy exercise to encourage staff to actually take up positions rather than being made redundant. They added this permanent retained pay, a bit of an extra each month in their pay packets. They realised that this was unsustainable commercially. So a few years later, they wanted to remove the permanent retained pay terms. And the way they wanted to do that was to dismiss all staff who had it if they didn't agree to changing it, and then offering to re-engage them on inferior terms and conditions. Inferior meaning no longer having the permanent retained pay. So many staff did actually agree to it, but those that didn't were threatened with dismissal. Now, they had Asda behind them, who went to the High Court, and the High Court granted an injunction. Unusually, the injunction was actually to prevent Tesco from giving notice of dismissal, which they're perfectly entitled legally to do, as long as they do it fairly. But they did get the injunction. Tesco went to the Court of Appeal. The Court of Appeal overturned that injunction, and it went to the Supreme Court, and that was heard on the 24th of April. So we're waiting for the outcome. In this particular case, the issue was the word permanent. And one of the main takeaways from this was you must always use clear language when offering benefits as an incentive. You should always say they should be subject to change or withdrawal in the future. But more widely, it's quite interesting due to the increasing criticism of fire and rehire as a practice. And I'm sure you all remember back in 2022, P&O Ferries just basically sacked loads of people, offered them jobs on lower salaries. Most of them didn't take them. The issue there is that when you dismiss someone and you offer them a new role, the tribunals will always expect someone to reduce their losses by taking whatever's offered to them. So actually, by offering them a new role, you're essentially giving them a chance to reduce their losses, mitigate their losses, which will affect any award that they may get if they were to bring a claim. P&O obviously felt that it was cheaper to do that, cheaper to sack everybody than actually keep paying them as they were. It does remain lawful in the UK, and it can be a useful mechanism in the right circumstances, firing and rehiring on lesser terms. But it's becoming more and more unpopular, and actually Labour have indicated that they would outlaw it altogether. What has come in now is a statutory code of practice on fire and rehire, which makes it clear that it has to be a last resort. It doesn't require employers to contact ACAS if they're going to do it. The code recommends employers should engage with employees as early as possible, share as much information as possible, engage in consultation for as long as possible. As it's a statutory code, if you don't do that, then the tribunals can award up to 25% more to any compensation. I said that one of the impacts of the new REUL changes is changes to TUPE consultation. At the moment, businesses with fewer than 10 employees can inform and consult employees that are going to be potentially affected by TUPE. But anyone with more than 10 employees has to arrange elections for employee representatives. I know in practice this doesn't always happen, and employers do negotiate directly with more than 10 employees, but that is unlawful. Not anymore, though, because the regulations have removed the requirement to elect employee representatives for TUPE purposes if you've got fewer than 50 employees, which absolutely makes sense because it's so much easier to deal with people directly and to avoid the time-consuming elections that are necessary. If you've got more than 50 employees, but you're only transferring 10 or fewer, you also don't have to elect employee representatives, and this will come into force in July. As I've said, no other changes are being proposed to any of the TUPE consultation requirements, which perhaps is a shame because they're quite onerous, but that's where we are at the moment. So, religious or belief discrimination cases, there has been a lot of activity certainly this year, but over the last few years, by claimants who allege that they've been dismissed or undermined or treated unfairly for expressing gender critical beliefs. And I'm sure you've read about some of these in the papers. And this is only one of many different types of protected characteristics. And a philosophical or religious belief is a protected characteristic. And there are certain rules about how you actually identify whether something is protectable under law. But at core, employers have to deal with fundamental differences in values and beliefs that emerge between colleagues. People have very strong feelings about this. This often leads to grievances, it often leads to claims. Obviously, under the law that we have, freedom of expression, you have an absolute right to hold your beliefs at work, but not an absolute right to express them. And there is a big distinction. So employers are allowed to impose restrictions on what workers can say, but these have to be reasonable. They have to be able to justify those restrictions. So that's a difficult balance to strike. And a recent case, Higgs and Farmer Schools, was an employee who's dismissed for expressing beliefs that gender can't be fluid and an individual can't change their biological sex or gender. It isn't finished, this case, so permission to appeal the Employment Appeals Tribunal decision has been given, so it'll go to the Supreme Court. But the Employment Appeals Tribunal set out basic principles of that balancing approach and basically reiterated that you can express your views. It's an essential right in any democracy, whether or not your view is popular or mainstream. And the manifestation of the way you express that belief will be protected, but not where the law allows for the restriction of that expression because other people's rights and freedoms need to be protected. It sounds a bit sort of esoteric, but if you do actually have this kind of problem at work, this becomes very, very real. And you always have to consider when you're looking at how to deal with this kind of issue, whether your objective is sufficiently important to justify limiting the right of an employee to express themselves, whether or not the way you limit it can be imposed in a different way, and balancing the severity of the limitation on the rights of the worker to express themselves against the importance of that outweighs the latter. So sorry, that's an awful lot of words, but it does actually make sense when you look at it in the light of the guidance given by the Employment Appeals Tribunal. And they actually were quite specific. You should always consider what's being said, the content, the tone, the likely audience, the impact on your ability to run your business, whether the employee made it clear their beliefs were personal or whether it could be seen as representing the views of the employer, whether there's a power imbalance involved, the nature of your business, do you have vulnerable service users or clients, etc. And gender critical beliefs are protected characteristics under the Equality Act is one of the outcomes of this case. I've only given one example of Cave against Open University, that there are many where somebody's belief has not actually been protectable. So, for example, being a member and passionate about the BNP is not protectable, any political party. Mr. Cave was an anti-feminist. His belief was decided to not be protectable. So there's quite a lot of case law on what actually is protectable. Neurodiversity is another big issue. I'm getting a lot of inquiries really about employers who are realizing that some of their employees do have, or their employees are telling them as well, that they are neurodiverse in some way. And there are a few companies, and I can recommend a few, if you need any help in dealing with this kind of thing, in producing policies, because it's only a matter of time where, and already has happened actually, where tribunals are protecting people who are neurodiverse. So one example is Borg, Neal and Lloyd's Banking Group. The claimant had been there a long time, no performance issues. They were going through actually a race education course, and he used a racially offensive word within the context of asking a question about what he should do if a black employee used the word. When there was a silence, because the trainer didn't know how to answer this, he actually used the word. He immediately apologized. The trainer was very upset. A couple of people on the call were very upset. He was mortified, obviously, but he was sacked for gross misconduct. Now, he brought claims for unfair dismissal and also discrimination. The unfair dismissal claim was successful, partly because the employer actually was very rigid in the way it approached this. It didn't give anyone a chance to apologise. The trainer who was upset about this actually said she did not want him to be dismissed or even disciplined. Anyway, the unfair dismissal claim was upheld. He also, though, interestingly, succeeded in a claim for discrimination. The employment tribunal said or heard medical evidence that his dyslexia could cause him to impulsively say things when concentrating on complex questions. And that meant that his inappropriate language was actually consistent with his disability. Therefore, his dismissal was disability-related discrimination. And the bank said that actually, okay, it might have been discrimination, but it was justified in the context of what had happened. Tribunal wasn't having anything to do with that argument. They looked, on the other hand, at the profound impact of the dismissal on the claimant, and they thought that the employer could have achieved its aims in other ways by providing further training. So just interesting then, that words said as a result of a dyslexic characteristic was actually meant a successful discrimination claim. The actual employment tribunal was in trouble, where a dyslexic claimant was actually granted a rehearing because the tribunal itself didn't actually consider that inconsistencies in evidence could be related to his dyslexia. And that does have implications. Obviously, when you're hearing a disciplinary or a grievance and you have a dyslexic employee, it may be necessary, even if what they're saying doesn't make actual sense or there are inconsistencies, it's just worth noting that you might need to think about this. What should employers do? Acknowledge and adjust for neurodiversity in the workplace. There's a lot of emerging case law, as I said, so it's important to enhance a manager's understanding and awareness of neurodiversity to foster a more inclusive environment, reduce legal risks, importantly, even things like inappropriate comments. And I have had cases that I've been involved with where managers really have not understood people's outbursts in a way that they perhaps should have done. September, Predictable Terms and Conditions Act. This is a bit of a mystery, really. We'll see how it actually works out in practice. The regulations themselves as to how it will really work out and what the rules are still being worked on. But it basically gives workers and agency workers the right to request a predictable working pattern. So where they are on a fixed term contract of 12 months or less, or they have a work pattern that is unpredictable in the sense that it's not possible to write down, say, Monday to Friday, 9 to 5, and they want to apply for a change to get a more predictable work pattern, they can actually ask you for that. They can apply twice in a 12-month period. You can reject an application on the normal statutory grounds like the burden of additional costs or insufficiency of work. They can't make the request until they've been with you for more than 26 weeks. If they make the request and they suffer a detriment or are dismissed because of it, though, that's an automatically unfair dismissal. There is a new code of practice on this and guidance on making and handling requests. But as I said, I think this is just one to watch out for. Either nobody will even ever remember it and we won't worry about it, or there will be a lot of requests along these lines. So just to be aware of it when you're thinking about what your staffing needs are going to be, it's possible, even where you get someone in for a fixed term of less than 12 months or on unpredictable hours, that they would be able to apply to change that. October, Worker Protection Amendment of Equality Act. This is around sexual harassment. This is a new and positive duty on employers to take reasonable steps to prevent employees from being harassed. This is it's been in consultation for a long time. Labour are saying that they're going to extend it not only to sexual harassment from fellow employees, but they're going to extend it to third parties. So that would include your suppliers, your customers. You actually have to take steps to prevent sexual harassment against your employees from third parties. That's not in yet, but Labour have said they would make that change. You have a defence if you can show that you've taken all reasonable steps to prevent such acts taking place. There's obviously there are rules around sexual harassment and protecting your employees, but this is a positive duty. So you actually have to show that you have done something, you've thought about it, and you've taken all reasonable steps. There's a new code to be published by the Equality and Human Rights Commission. It's not out yet, but they'll have the power of enforcement action. So you may have the EHRC knocking at your door, trying to enforce this where they feel that employers have failed to comply. They will give guidance, though. So it's a question of watch this space as to what that guidance looks like. There'll be a compensation uplift of 25% on compensation for failure to comply. So this kind of compensation would go hand in hand with, say, a discrimination claim brought by somebody who believes they've been sexually harassed. They will add on, and my employer failed to comply with the Worker Protection Amendment of Equality Act. And as I've said, Labour have said they'll introduce or reintroduce specific liability for third-party harassment. So what are reasonable steps? Multi-dimensional. It's worth starting to think about. We've only got till October. Strong message from management about zero tolerance. Analysis of existing data to identify risk areas, i.e. where you're dealing with, I don't know, customers in a bar or suppliers that are uncontrollable. A staff survey, asking employees whether they feel confident to report incidents, and if they don't, why. Training to all staff, certainly to managers. Keeping a record of the training. Having ambassadors, like we've now got mental health ambassadors. We can have ambassadors for anyone who wants to chat about sexual harassment on a confidential basis. Look at how confidentiality would work within the workplace. Should it be every complaint just go to one director, for example, just to try and keep some kind of ring of confidentiality around these? Regular evaluation of anti-harassment and dignity at work policies. Just a plan, so that you can show that you have complied with this duty to take reasonable care steps to prevent sexual harassment. I've seen some employers putting up QR codes in toilets, with somebody can just report something, which I thought was quite a good idea. Just a few, there've been lots recently, cases. Nuns and Windermere Hotel, quite outrageous, where a head chef was really inappropriate to one of his chefs, Mr. Nuns, including singing the Ballad of Barry and Frida. I don't know if you know that, but if you do, you'll know what I mean. And to hear a national grid, I put this in here because of the amount of damages, £350,000 awarded in total. She, Ms. Tahir, resigned from her role. She was a trainee project supervisor after she suffered sexual harassment from her mentor. Then when she complained, victimisation against her, following her complaint. The employer actually admitted liability for her claims, so it really just went straight to a remedies hearing. I've included this because it just is a great example of what not to do. Firstly, they ignored her request to resolve the matter informally through redeployment. She wanted to just be moved and keep everything quiet. They placed pressure on her to bring a grievance. They initially rejected her formal grievance and then overturned that outcome on appeal and upheld her complaint. So it's very confusing, although that was the right outcome, obviously. They used the disciplinary process against the perpetrator as a means not to tell her of the outcome. They said it's confidential because we're having a separate process. They didn't give her any results, really, of what had happened. They failed to apologise, actually in tribunal when asked in evidence if there was any conduct that was regretted. They failed to dismiss the perpetrator after the grievance was eventually upheld, and they took so long over the disciplinary process that she resigned. So really, a really sad story for Ms. Tahir. But anyway, she walked away with aggravated damages. Family and carers' rights comes into force in April, but it actually becomes effective in October. From day one, 12 weeks paid leave if a child is in receipt of neonatal care for 16 months after it's born, and it's paid in line with SMP and SPP. Tipping, I think you'll probably all know about. It may be relevant to some, but there must be policies now on what you do with tips. All tips have to be passed through to staff. They have to be not equally distributed, but fairly. So a question of considering whether or not you want to pay equally, and if not, explain why. And you have to keep a record of tips received for 3 years. Employees can actually ask what you're doing to comply with this as well. There's a new data protection and digital information bill. Very boring, but actually quite important, really. And certainly I wanted just to highlight that you will have more reasons to refuse to respond to a DSAR, which I know will gladden many employers' hearts. The whole point of this bill was to make things easier for employers because it was getting quite difficult to deal with. But there are lots of other issues that it's bringing in as well. It'll make international data transfers out of the UK easier. Anyone who deals with data overseas will know that the difficulties that brings. It'll clarify that legitimate interests can be used as a lawful basis for direct marketing. I won't go on about those other changes, but just to be aware that the DSAR process will or should become more streamlined, and your opportunities to refuse one will increase. These are just interesting bits that I thought might be of some interest anyway. Age discrimination. Marriott against Hippodrome Casino. Was it discrimination when a bar supervisor commented that a claimant should not expect youngsters to do the work? And she was told to behave in a more grown-up way when she was seen quarrelling with a younger waitress about moving a glass. It was only that comment. Fortunately, the tribunal found, and this is unreported in the sense it only went to tribunal level, the tribunal found that the comment could not be seen as unfavourable treatment due to her age. It was simply indicating the supervisor felt she was behaving in an immature way. And another case, being called Christine Lagarde, is not discrimination, age discrimination, and that's Morgas against Deutsche Bank. And lastly, Richardson and West Midland Trains. Again, I just putting this in for interest. Mr. Richardson was summarily dismissed without notice following workplace pranks. Basically, he found out that one of his fellow employees hated spiders and insects, so he placed a tarantula's exoskeleton in her pigeonhole. He meant well, I suppose, but she did not take it very well at all. And the employer felt that the pranks were deemed to intend to cause lasting shock, leading to serious consequences. Actually, what happened is that the tribunal criticised them for doing that. The employee who'd been affected, who'd opened her pigeonhole to find the exoskeleton, actually did not want him to be disciplined. She herself described it as over-the-top banter. He expressed willingness to really sincerely apologise, but they didn't tell the lady involved that he was willing to apologise. They were criticised by the tribunal, partly as well because they had not recently, anyway, given the claimant bullying and harassment training. And he also had asked during the disciplinary process for them to call a particular witness, and they hadn't done that. And those were two actions that the tribunal criticised. And they looked carefully at whether or not it was reasonable to consider the prank to be so severe it should be gross and worthy of dismissal, or whether or not it was just very serious bullying. And they found that the employer didn't hold a genuine belief on all reasonable grounds that the prank was sufficiently serious. So this just underscores the need for a realistic assessment of the potential impact and consequences of employee actions, certainly against other employers, that you need to scrutinise the behaviour to determine whether bullying has actually taken place and consider whether the bullying actually does constitute misconduct, serious misconduct, gross misconduct, and how it's been received by the other employee concerned. That is the end of that. It's a real whistle-stop tour. Hopefully it was interesting. Hopefully it gave you some signposts as to things to watch out for over this year. As I said, next year will be even more. If the government changes, it'll be fast and furious in terms of employment law changes, and we'll obviously keep you updated as best we can.
Thank you for listening. If you enjoyed this episode of our podcast, you can subscribe to our monthly TLD Talks, covering a wide range of legal and management topics. You can also find TLD Talks on Apple, Spotify and Google. The details are also on our website, www.thelegaldirector.co.uk. If you'd like to know more about recent or upcoming changes in employment law, or the wider work of the legal director and how a part-time legal director can save you time and money, then do give us a call on 020 3056 8538 or visit our website.